You're watching the award-winning GHS-TV, Germantown Community Television, your hometown news and information station.
Welcome back. With us is Edgar Davison. We were talking about employment law. Ed, before the break, we were talking about, what your employer has to give you as you're exiting the building on that day you're discharged or fired. What requirements, because I think there's COBRA and probably your last paycheck and some other things out there. So what all do you need to be paying attention to over the next few weeks?
Right. They generally have to provide you with a COBRA notice, and that notice will be mailed to you. I say generally, they always have to provide you with a COBRA notice. There are very stiff fines if they do not provide you that notice. So that's the number one thing. If your employer hasn't provided you a notice, you should probably seek an attorney about that. The second thing is your final paycheck. That's due within 21 days of your termination or the next pay period, the next time you were supposed to get paid, whichever is later. So generally that would be 21 days. They have to give you that. A lot of people ask me about vacation pay, earned vacation pay, and that's, in Tennessee, they typically don't have to pay you that unless there's a provision in their handbook or there's some type of policy or contract where they do have to pay you that. So your earned vacation time, you're generally, unless the company has a policy of paying that, you probably won't get that, even though it was earned the year before. Those are the general things that your employer has to provide you after a termination.
What about if you get paid for sick leave and you've accrued sick leave? Do they have to pay you that?
Not generally. Sick leave is, it depends on the company policy, really. If they have a policy of paying that, yes. If they don't, well, then it's very questionable whether they have to pay you that.
And then, you had talked about the COBRA notice. Is there some sort of time frame in which they've got to get that notice to you?
Yeah, they generally 30 days. They have to mail it to you within 30 days. If they don't, like I said, they can face some pretty stiff penalties for that. And there's actually a cause of action for that.
Yeah, I've seen where they mail it out in 60 days, but they date the letter as if it was 30 days and got lost on somebody's desk, which is always entertaining.
You're right.
But, say you're an employer, how do you make sure you've got policies in place to make sure all of this gets done?
Well, that's one of the things that employment lawyers on the employer side handle. They do a lot of training. You make sure you have a good handbook with all the policies and procedures, a good anti-discrimination policy, no tolerance harassment policy. You want to make sure you have all those policies in place and make sure they're posted where everyone can see them and where no one can claim that they've never seen this particular policy. Handbooks, posters, there's certain posters that are required in the workplace that, all the different laws. You see, if you go to your employer, you'll see those posters if you work for a larger employer especially. That's all required, and that's all, you need to take those steps to ensure that no harassment's going on in the workplace. And if it is, you need to have a good human resources department to take care of that, or someone in charge that will take care of that if you're too small to have a HR department.
And I guess one thing for if you're an employee and, you should make sure you've gotten copies of all those policies and you keep those.
That's absolutely correct. You need to make sure that you have a copy, especially if it ever goes to litigation. You hope that it never does, but you want to keep all your documentation from your employer. store it somewhere, including old manuals. I would keep up with those just in case. You can always obtain that later from the employer, but sometimes that's more difficult.
Yeah. Now, this is always sort of the interesting thing. If I think I've got a case or whatnot, and I'm looking to find an employment attorney, what sort of questions, if I, get a list and all of them, what sort of questions should I be asking to figure out whether or not they're competent in this area?
Well, I would ask them, how long have they been in this area? How many cases that they handle? What their caseload is like? What type of litigation experience they've had. These cases can become very litigation heavy and very document intensive, and you need an attorney who's had some litigation experience. Those are the main areas. Of course, ask, how much they're going to charge you. In these cases, there's typically, there's a lot of times an hourly rate attached, depending on the case. Contingency, lawyers do contingency on these cases also. But a lot of times you will have to pay something, just because these cases are very difficult. Employment cases are tough on the employee side, and the success rate is overall for America is very low compared to, like, say, a car wreck.
Right. And I guess the easiest answer to all of that is they can just call you and not worry about having to worry about qualifications.
That's right.
Our time is up for this edition of LegalEase. I would like to thank our guest for taking time out of his busy schedule to be with us and sharing his thoughts and insights. If you would like more information about LegalEase or any other program on GHS TV, please refer to our website at www.ghstv.org. Thank you for joining us today, and be sure to join us next time for more discussion on legal topics. Until then, I am Vince Perryman, and thank you for watching.